Good morning and welcome to the 22nd meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. We have apologies this morning from Pam Gossel, and Marie McNair will be joining us online. Our first agenda item is to decide whether to take item 4 in private. Are we all agreed? We're all agreed. And our next agenda item this morning is evidence taking on the children withdrawal from religious education and amendment of UNCRC Compatibility Duty Scotland Bill. This is our second evidence session taken on this bill, and we will hear from two panels this morning. I'd like to welcome our first panel, and we are joined in the room by Juliet Harris, Director, Together, Scottish Alliance for Children's Rights, Gina Wilson, Head of Strategy, Children and Young People's Commissioner Scotland, and Gavin Yates, Executive Director, Connect. And we are joined remotely by Louise Church, MSYP, Galloway and West Dumfries, Member Education and Lifelong Learning Committee, Scottish Youth Parliament. You're all very welcome this morning. We're now going to turn to questions from members. Please indicate to me if you'd like to come in to respond to a member's question or to any of the points that are raised. And Louise, if you wish to come in, please type R in the chat function and the clerks will bring that to my attention. So we're just going to head into the questions, and I'm going to kick us off. Last week, the committee heard from 3 different panels, and they were all quite critical of the bill in various ways. They weren't supportive of it. Can I ask you, what are your thoughts on the general principles of the bill? And I'd like to come to you first. Yeah. I thought you indicated, yeah.
Okay.
Thanks, Juliet.
Together, Scottish Alliance for Children's Rights, we have been campaigning, particularly with the Humanist Scotland, for a very long time for religious observance to have an opt-out, an independent right to opt out for children and young people, as well as the right to opt in. So we definitely welcome the fact that Scottish Government have introduced a bill around religious observance. But we don't believe that it actually addresses the kind of key point that we've been campaigning for. As you'll have heard from evidence last week, then what the bill does is only allow for children's views to be taken into account when parents decide to opt their child out. It doesn't actually provide for children's views to be taken into account as to whether they're included, and it doesn't allow them to opt in if they want to. So broadly, in terms of your question, yes, we welcome the fact that Scottish Government are looking at this issue, but we don't believe the bill as it currently stands actually does that. Obviously, there are 2 parts to this bill, and it's really important that the second part of the bill around the amendment to the UNCRC Act does get sufficient scrutiny across the committee and in the parliamentary process. We are broadly supportive of the amendment that's being made through Part 2 to the UNCRC Act. We see it as a way of addressing systemic issues, children's rights issues, at a primary legislation level, but we do believe that there needs to be improved safeguards to ensure that children and young people still get child-friendly access to justice in relation to the changes that have been made.
Okay, thank you. Gina, would you like to come in?
Yeah, thank you. Our views are broadly similar to that as well. So we see the purpose of Part 1, although as it currently stands in the way that it's been drafted, we can't support it because it is solely amending a UK Act rather than introducing a standalone bill, which would then allow it to be in scope for the UNCRC Act. And as Juliet has described, doesn't actually include the opt-out, which was the concluding observation recommendation for children and young people. So although we support the intent of bringing legislation in this area, as Part 1 is currently drafted, we can't support it in its current form. Important as well for us to point out that religious education and religious observance have been conflated in this bill, and I know that's something you heard a lot of evidence on last week as well, that we believe there should be a clear distinction made between the 2 of those, and would prefer to just be discussing religious observance. On Part 2, we are not opposed to the amendments that have been proposed here, but we do have some suggestions about further amendments that we think should be brought in order to make sure that any potential negative consequences of those amendments are minimised for children and young people. So I'd be really happy to go into more detail on that later on.
That's great. Thank you.
I wish I could offer more solace to the Scottish Government, but my organisation has some deep concerns about the bill. I won't, we are not a legal organisation. I always turn around to my team and say, we're not lawyers, don't offer legal advice. So on part two, I think I'll be rather more circumspect about what I said. But on part one, we have the same concerns as my colleagues. The conflation of RO and RME together, we don't think is particularly helpful. But I would remind the committee that parents are, if you like, we're not homogenous. We'll have different views on these matters. And listening to the evidence last week, there seemed to be a line of questioning which was, it doesn't affect many people, so therefore it somehow, the effect is lessened. But the things with things like this is the people it does affect, it affects very, very deeply. I remember Peter Peacock, one of the former members of this Parliament, saying a few years ago that Gaelic, for instance, didn't affect that many people in terms of the population of Scotland. But for those that it was important, it was the most important thing. And this is, I think, the circumstance that you have here. Parents of faith and parents maybe of no faith will see, with the bill as it's currently drafted, a potential conflict where schools will end up having to be the arbiter of who is, has the capacity to make a decision in terms of a young person, which teachers and schools aren't really trained for. So I think that, unfortunately, there is a lot of weeds in this. There is a lot of granular detail that hasn't been addressed so far, and therefore I don't find that part one of the bill at the moment is supportable. I'm a great believer in the kind of Hippocratic view of things. First, do no harm. And my fear with this bill is we could end up with a situation where parents, and remember that parents are not an optional participant. We're not an optional participant. Article 5, Article 14 of UNCRC says that we have an obligation to be involved. So therefore, as I said, we have deep concerns.
Okay, thank you. Louise, would you like to come in on this? Okay.
So we don't support nor support. We think it's really important that young people are in this discussion the whole way through, and it does give them the independent right. I will just focus on part one, but yeah, we think it's really important that young people are welcome to this opportunity and made sure that it's clear that they have this opportunity through this bill.
Okay, thank you. We're now going to move on to questions from Maggie Chapman.
Thank you very much, Karen. Good morning to the panel, and thank you for joining us this morning. I'm just interested in exploring a little bit of how things work now and what this bill could then do. So, could you tell me, in your experience, and if you work with young people, what they tell you about how the right to withdraw from RO and RME, and I take what you say about the conflation in this bill, Gina, of those two things, but how it currently works. What's your view on that? What do the young people who you work with tell you about that? Juliette, I'll start with you.
I think a good form of reference for this is the Humanist Scotland's recent report, Preaching Isn't Teaching, which really collates both children and their parents' experiences of how this works in practice. I think a really important point to start on is the fact that religious observance and RME are repeatedly conflated. Even in the Scottish Government's own child rights impact assessment, they say that we're going to talk about them under the same heading to make reading easier. They're really different. Religious observance is about acts of worship. And I know that the guidance says that it should be time for reflection, but we know from the Humanist report, from our conversations with children and young people, that actually religious observance is often delivered in a way, mainly in a Christian way across schools. So religious observance is actually making children practice religious worship, sometimes against their will. Religious and moral education is actually a fundamental part of Article 29 of the UNCRC, the aims of education. And so it's really about making sure that children and young people learn about tolerance, about peace, about different cultures, about different religions. It's so important that religious and moral education is should be a core part of the curriculum. It should be a core part of children's right to education. So the conflation is a real issue for us, because we do say children should have the right to opt out or opt in of religious observance in line with their capacities under Article 5 of the UNCRC. But we actually say that RME should be a core subject that all children and young people have as part of their right to education. What we also know is that parents are often unaware of the right to withdraw. Children and young people are also often unaware of the right to withdraw. And again, drawing attention to the Scottish Government's own child rights impact assessment, they did research that showed that I think only 30% of school handbooks, this roughly, I'd need to check the impact assessment, but only about 30% of school handbooks actually talk about the right to withdraw. And so there's a really, as a result, actual withdrawal numbers are really low. Scottish Government anticipate that this would only impact on about 4,000 children. I do wonder if perhaps there's better awareness of the right to withdraw than if those numbers might be higher. So as it works at the moment in practice, I would say in summary, there's a complete conflation between religious observance and religious and moral education. Children and young people tell us that. The Humanist report is really clear that that is what happens. Parents don't know about the right to withdraw, so that must mean that children don't know about their right to withdraw. And everything that children and young people tell us is that they want to be active agents in their own education. That helps them to feel empowered. That's a core part of Article 29. So they should be involved in all decisions relating to their education. And at the moment, they're not.
Thanks, Juliet. Gina, do you want to?
I would entirely agree with Juliet on that. A clear national overview of children's experiences of religious withdrawal doesn't exist. So we can't tell you what it looks like for all children across Scotland, because that information just isn't there. But what we can tell you from our work and the work of others on education reform is that children have lots of constructive ideas about how to improve their school experience. They want a varied curriculum that gives them skills and knowledge that's relevant for the world that they live in, and they want choices about what they can study and how they're able to follow their own interests and their own pathways. Last year, because you did ask the question, what are children telling us about their experiences? Last year, we recognised that there was a real gap in evidence about what children's experiences and views on discrimination based on religion and belief were in Scotland. So we commissioned some research to look at what children's experiences were. We did that research with 11 to 25-year-olds. There were over 2,500 young people responded to that. And what that told us was that 17% of respondents had experienced discrimination or negative comments based on their religion or belief. And when that was broken down by the religion of the respondents, it was 53% of Muslim respondents had experienced discrimination due to their beliefs. More than half of those who reported having experienced discrimination reported having experienced it at school, college or university. And more than half of all respondents, so half of all the 2,500, had witnessed other people experiencing discrimination or negative comments due to their religion or belief. And once again, the most common location was in school, college or university. So I think for the broader discussion that we're having, that's a really important context for us to bear in mind about experiences children are currently having.
Thanks, Gina. Gavin and Louise, I'll come to you on this as well. But Gina, you talked there about the evidence that we have from children and their experiences and their families' experiences, and the points you were making there about discrimination and the experience of that. Is there any evidence that you're aware of that talks about how parents or even children might be worried of being othered, being further stigmatised if they take a position on withdrawal or not from RO?
I'm not aware of that,
Okay.
of that specific issue. We certainly hear a lot, though, from children and young people about the experience of feeling othered in school. I wouldn't be able to talk to that specifically in relation to their experience of withdrawing from religious observance or religious education, but I do think it talks to the broader point that Juliet was raising about the importance of the place of an inclusive, pluralistic and broad religious education for children, to ensure that we are exposing children to the ideas and an understanding of people around them.
Okay, thanks, Gina. Gavin?
I can only agree with my colleagues on this. Parents aren't aware. The interesting thing about school handbooks is there'll be a lot of parents that are unaware that there is a school handbook. You know, they're not issued anymore. They might be on a website, they might not be. This is an issue that comes up from time to time and needs to be addressed. I think, my colleague's concerns about the conflation of RO and RME is important. Yeah. Connect as an organisation strongly supports religion, RME in terms of its philosophical, sociological and historical perspective as being a really important part of a young person's education. So we're absolutely in lockstep on that. I think, though, is the practicalities of this, and you were talking about othering, and I think that's really important, is that sometimes it's the path of least resistance is the way that will go forward. And it could be that, say, a young person might actually say to their parent, I'm not very comfortable about religious observance. But what would happen is nothing would happen because it's too difficult. It's going to be stressful. What's going to actually happen in the school? How's it going to be managed? Can you imagine a situation if 40% of the year group decided that actually this isn't for me, where they're going to go? So, whilst we like to talk about all of the wider things, it's this granular detail that actually will decide whether this can work or not.
Yeah, and that was one of the things we heard from our panels last week was exactly schools aren't equipped to deal necessarily with this. So maybe that's one of the reasons why they don't make too much of an issue of it.
This for me is a child welfare point as well. Is if teachers really aren't prepared or trained to be able to deal with fallout on this. If there was a conflict, if you like, between parent and child, and it's the teachers that are having to pick up the pieces in the middle, have they got that training? Have they got that expertise? I'm talking all the time about the lack of counselling that we've got in our schools for young people with mental health issues. I don't think this particular course of action is without consequences. Notwithstanding that, though, RME is an important part of the curriculum, and certainly it's something that we would be keen to make sure that stays in place.
Okay, thanks. And Louise, if I can come to you now, same kind of question, your experience and those of your MSYP colleagues, but also the general discussion you have. How is this working in schools at the moment? You're probably, you are closer to having been through schools than any of us in the room here. So really keen to get your thoughts, your views on this.
So at the moment there is nothing that shows us that withdrawals is something that happens often or something a lot of people know about. It's not something that's discussed often, and it also depends what kind of school you go to, if it's a non-denominational school or if it is a religious school. But it's not something you tend to hear about or talk about within the school, within your peers, or with any adult that has children in school. Moving forward with the withdrawal, RO and RE being together does cause a difficulty with it, just because RO is not a subject, it's something that happens within the school, and obviously RE is one of your subjects within school, so that causes a little bit of conflict with it. As RE, as I say, we believe that it is vital for every young person to have a basic understanding of religion and everything that comes with it. And RO is obviously different people coming in talking about different religions. Obviously it can be against your religion, which means the withdrawal will be good in the fact that you don't need to listen to a religion that's not yours, or be practicing a religion that isn't yours or you don't believe in. So yeah, that's where the kind of conflict comes in with the withdrawal process. It can be a daunting thing having to go up to a member of staff and say, I'm not comfortable with this isn't something that I want to do or be a part of. So it's just making sure that it's not an intimidating process or a scary process for a young person, because for a young person to speak up and do something like that is big in itself. So it's just making sure all them processes and policies are in place to help that young person.
Thanks, Louise. That's really helpful. Just on that last point, what do you think a good process would look like? One that wasn't intimidating. What would that look like? What would that feel like for the young people?
So, talking with the other MSYPs, one of them was they can pick a trusted adult within the school facility that they think will help them through this process. It's not always your pupil support, it's not always your counsellor, it's maybe that teacher that's taught you for a couple of years that you've created a bond with, that is that type of person you want to be with you throughout this process. So it's little things like that, little things that make them feel a bit better, being listened to before anyone answers you, like just hearing that young person out throughout this process. It's all them tiny little details that make all the difference.
Thanks, Louise. That's really helpful. My final question, and this is to any other panel, really, you've all in different ways said that the way that the process currently works, we don't have evidence of high numbers, but that could be because of lack of awareness, it could be because of stigmatisation, it could be because of just it's the line of least resistance, I think, Gavin, was your phrase. Should we be monitoring and actually gathering data on this, because it feels quite piecemeal? There's no requirement to record. There's no sort of gathering of data within local authorities formally, and I just wondered what your view was of whether or not we should be actually having a clearer data-driven understanding of this, or whether that's maybe not the role in something like this. Juliet, go for it.
I think it's striking how little data there is when we're looking at this bill in Parliament at the moment. So I do think that would be helpful. But I think it's absolutely essential that we don't miss the nuances that Louise has really eloquently put across today. I think data in itself doesn't get across children and young people's views. And I think that's what we really need to know about. How are children experiencing this? How often are they experiencing this? Are there children and young people who want to opt out? And despite, I think, the work that the Humanist Society Scotland has done to try and bring in children and young people, the brilliant work of the Scottish Youth Parliament, I still feel that that's actually the area of information that we know the least about, is what children and young people think and experience, rather than the kind of spot check of data.
Thanks, Juliet. Anything to add, Gina?
I do think there is a legitimate case to be made for more data and information on this. We've never had a thematic inspection or review of anything on religious observance, which would probably be really valuable for us in understanding how is religious observance actually being delivered in Scotland, because we have non-statutory guidance that sets out how it could be delivered, but we know from hearing the examples that the Humanists and other panel members spoke about last time that often it's not being delivered in that way. It's been delivered quite differently. So it's difficult to get a real picture of what is actually happening. I think, as Juliet said as well, though, there are fundamental rights issues here in terms of children being able to choose whether or not they are involved in religious observance, which probably could progress without the need for that information. But I do think there is a case that we do need more data.
Thanks, Gina.
I come from a position where knowledge is power, and I'd like to see more data, obviously, but somebody's got to record that. And I'm sure when you speak to teaching unions, they'll be saying we've got enough on our plate already. We haven't even got accurate ASL data on CMUS at the moment. You know what I mean? So the other thing is, if we were going to do something like this and you're going to record that data, you're going to have to run it for a year to get anything sensible. So unfortunately, it's not where we want to be, but it's where we are.
Okay, thanks. And Louise, is there anything else you want to add just on how things are working at the moment, or how we record things?
Can't really say much at the moment because we don't know how it kind of works at the moment. I think it would be good to have it monitored and see people removing themselves, but I don't think it's something that needs to be a top priority throughout this process.
Okay. Thanks, folks. Thanks. I'll leave it there.
Okay, thank you. We'll now move to questions from Paul McLennan, please.
Thank you, Convener, and thank you, panel. I suppose it's just a little bit more on the specifics. We talked, obviously, about withdrawal from Arrow and RME, and it's kind of more on the process. So there's a kind of three-part question. The first one is about the requirement for schools to inform a child if their parent asks for them to be withdrawn from both or either Arrow or RME, when the request has been made, the child is given an opportunity to express their views, and the school must seek to have a discussion. And a child must respect the child's wishes if their view differs from their parents. So again, I know you've kind of touched on around about this, but it's more on the specifics that's proposed in the bill. Julia, I'll probably come to yourself first of all, and your thoughts on that.
Yeah, certainly. I think it's important to start that kind of thought process by basing this discussion in the UN Convention on the Rights of the Child. So we've talked about Article 5 of the UNCRC, which is all about the evolving capacities of the child. And this really means that as a child grows up and becomes a young person, they're in a position to be able to make more decisions about things that impact on their life. When they're very young, obviously parents and their carers are the ones who make the most fundamental decisions about their lives. So I think basing this in Article 5 of the UNCRC, and what we were talking about earlier about the low awareness of parents of the right to withdraw a child, I think if there was better awareness of the right to be able to withdraw from religious observance, then that would mean that the conversation would start earlier in the process. It would be something that begins when a child first goes to school. Parents and carers may talk about, do we want our child to take part in religious observance or don't we? And I think having that awareness from a really early stage supports Article 5, which means that the parents can support the rights of the child, and it all becomes centred around that child. I think continuing that conversation into secondary school, then parents are having conversations about the capacity of the child all the time. They choose, should the child be able to walk to school? Should the child be able to decide what skirt to wear to school today? So they're always assessing the capacity of their own child. And I'd say teachers are doing the same all the time as well. Is this child old enough to read this book? Is this child old enough to be able to lead this small piece of group work? Is this child old enough to be able to decide if they want to put their jacket on when they go outside or not? So evolving capacities, it isn't something that's that complex to get your head around. Teachers and parents are constantly assessing the evolving capacities of the child. So if there's awareness of the right to withdraw or opt into religious observance from an early age, I do believe that conversation won't be as complex, won't be as difficult as people have anticipated, and it'll become a natural part of really that child realising the aims of education. So I also think that taking that approach, basing things in the evolving capacity of the child, means there's less likely to be conflict between parents and children. There's also less likely to be conflict between schools and parents. I think one final point that's really important to remember is that religious observance is a really small part of a school year. It's not hours and hours or days and days of a child's class. So it's not a child themselves withdrawing themselves from religious observance isn't infringing on the right of that family to practice their own religion, to take that child to religious worship, whether it's a mosque or a church or a synagogue in their own time, to celebrate religious festivals. All of that can happen within the family space. It's just a really small decision in relation to a really small element of what happens within that school life. So I don't anticipate, if it's done well, that there will be as many conflict or as issues as perhaps some people giving evidence have put across.
Okay. Gina, Gavin, and then I'll come to yourself in a wee second, Louise, if that's okay. But any other thoughts?
Yeah, thank you. I support all those comments as well. You asked about the proposals. The proposals themselves are muddled and inconsistent. Why should a child be able to choose to continue to attend religious observance over their parents' objections, but not be able to opt out if their parent insists that they have to go? Is it because in practical terms the opt-in is easier for schools to manage? And if that's the case, that doesn't really sound like a rights-based decision. Our position is that where a parental right to opt out exists in relation to religious observance, the equivalent right must be extended to children in line with their evolving capacities. We don't consider a bright line age limit is something that's needed on the bill. I know that's something that you discussed as well. Our expectation would be that the extension of the right certainly includes children of secondary school age and may include younger children depending on their capacity. So having that age limit on the bill wouldn't be helpful for this. Age limits tend to be more useful where it's around child protective measures like the age of criminal responsibility or the age at which you can purchase alcohol, those types of things. We don't agree that the current proposals meaningfully align with the concept of evolving capacities because they don't allow children to acquire an increasingly active role in exercising choice through adolescence. Children's role in the proposals as they're drafted at the moment is passive and asymmetric, which you've heard a lot about. The general comment 12 on the rights of the child to participate in decision making is also relevant here. Makes clear that as a child ages and in line with their evolving capacities, the role of parents transforms from direction and guidance into reminders and advice and later on an exchange on an equal footing. Yet the current proposal doesn't put older children on an equal footing with parents, even at ages where currently in existing Scots law, children's capacity to make decisions like the Age of Legal Capacity Act, they have no additional decision-making powers under these proposals. Even 16 and 17-year-olds wouldn't be able to opt out of religious observance without parental permission, even though they could make the decision to leave school.
Yeah, and I'll come on in a wee second about, you talked last week around about, or we talked last week around about the process if a child is capable of forming a view, and that's part of the process. And there was mixed views kind of saying, look, it should be secondary school age and that kind of stuff, but you've kind of answered that question in terms of that. So, Gavin, I don't know if we want to pick up the points there, but on that one as well, because I think when we talked last week, there was the view around about where's a child capable? You can get a mature 8-year-old as against an immature 12-year-old.
Exactly. Capacity to make decisions isn't a golden thing. It's not 14. In fact, I've got an issue at the moment where I've got a local authority talking about safe routes to school. Is the local authority says, of course our routes to school are safe, as long as you're walked by your parent at the age of 17. So the things about this is that there are some kind of ridiculous matters. As I stated at the opening of this, parents are not an optional participant under the law, right? The 1995 Children's Scotland Act lays out a number of responsibilities for parents. Article 5, Article 14 talks about the parents' right to be involved in their upbringing, right? Whilst I agree with my colleagues, and obviously Connect as an organisation, we're a child rights organisation as well as a parental rights organisation, and we believe that young people that have necessary capacity should be taking these decisions. But the problem is when you end up with, if you like, a hierarchy of rights, where you've got parental rights under the law and under UNCRC, which are apparent and in statute there, and then you've got rights of children as well. It's how do you balance those effectively? Now, I'm not saying it's beyond the wit of man to be able to do that, but it puts an awful lot of pressure on the schools to end up holding the coats, and I don't think that's a position that they particularly wish to be in.
Gavin, thank you for that. Lise, I don't know if you've just heard what everybody said just on the points. I don't know if you've anything else to add.
Just that young people should be involved from the word go, just to create that sense of they feel like they have a right to talk in this conversation and to stop conflict. The quicker they're involved and the quicker they can get their views across, the easier it is to resolve any issues that may arise. Don't be forced to opt in or out. It is their choice, especially if they want to opt in. They're learning, it's education. Education is key. So if they want to opt in, that's great. They want to learn, that's not a problem. And the same with opting out. If they don't want to learn about it and feel like it's against what they believe, that's totally fine as well. Just making it clear that opting in and out is both totally okay. And there shouldn't be an age on it. Everyone matures differently, everyone thinks differently, so putting an age on it doesn't help all that much, especially when it comes to our role. And yeah, just making sure that they're involved through the whole process, just to make it run a bit smoother.
Okay, thanks, Louise. One other question, Convener, if that's okay. We've kind of touched on this one as well, and it kind of talks that the Scottish Government's assertion is that the new process will support Article 12 and Article 14. You've kind of all touched on that, but it mentioned about Article 12 and Article 14. I don't know if you want to add anything on that. I'm pretty clear the views that are coming through in terms of that, but does anybody want to add anything particular in about the assertion for government about the Article 12 and Article 14 of UNCRC? If anybody wants to add anything that they've said already. Julie,
just briefly, I think it's come across clearly, but we don't believe that it does actually comply with the UNCRC as it's currently drafted. And I think, as well as Article 12 and Article 14, well, particularly Article 14, we need to be thinking about Article 29 and about the aims of education. So I would say, to further the UNCRC, it's absolutely essential that children have the independent right to be able to opt out of religious observance as well as opt in to religious observance.
Okay.
And we would also say it's absolutely essential that the conflation of religious observance and religious education is removed from this bill, and that opt-out only applies to religious observance and not to RME.
Okay, thanks. Gina, Gavin, I don't know if you have anything else to add. I think you seem to be nodding away there. So, same yourself, Louise. Anything to add? Everybody seems to be in agreement with that. Convener, thank you.
Okay, thank you. Now questions from Rhoda Grant, please.
Thank you. Just as a follow-on, really, from the answers given, do the whole panel agree that RME should actually be out of this bill, that it's part of the curriculum? There shouldn't be an opt-out at all for it. Is that what you're saying?
Yes.
Yes, and for a very good reason, right? Is if you keep it in, right, and you allow part of the curriculum to be removed, well, what's next? PE? You know? So there really needs to be a separation here between what is part of the curriculum, which is, you know, historical, philosophical, sociological look at the world's religions, and religious observance, worship, which is a separate entity altogether.
Okay. Louise, do you agree?
Yeah, RE is education, and it is really, really important. Everyone talks about going into the workplace and working with people with different religions, so having that basic understanding really helps people. And having RO and RE in the same thing and coming up with this bill does create a bit of conflict and a bit of situation where it's like, well, does it apply to this one or this one?
Okay, thanks. So I suppose turning that on its that argument on its head slightly, should RO be a legal requirement in the first place, or is that I know that's quite controversial, so I don't want to put anyone on the spot, but given that this bill is really there to allow an opt-out.
We're a membership organisation, so I do consult with our membership on anything that I would put across to the committee, and that's not something that I've spoken to the membership on, so I couldn't comment.
Okay.
I wouldn't be able to offer an office view on that either, but it is notable that RE and RO are the only part of our curriculum that have this statutory basis, and I suppose we need to be asking the question, why is that appropriate still? Is that still needed? But I couldn't offer a position beyond that.
Okay.
Sorry, but you know, parents are not homogenous, and they all have very, very differing views.
Okay, Louise, are you going to avoid answering my question like the other three have?
Unfortunately, there's not able to comment or add anything to that.
So that's perfectly okay. I've got no answer, but I absolutely get it that people don't want to come down on one side or another, especially when they're here representing others. Can I move on a wee bit? And this has been touched on as well, about the conflict that this could cause. I think we've heard before, it's quite strange that it's the parents that have the opt-out right other than the children. The children don't have an opt-out right under the bill, but what they do have is an opt-in right if their parent opts them out, which seems a bit kind of back to front. Do you think that will cause conflict, or is it likely to be less conflict because it's the parent expressing the right and the child is likely to go on with it? I don't know. Louise, do you? I'm picking on you first because you probably understand better what could cause the conflict between parents and children. Oh, you're on. Can you start again? Sorry, they were a bit slow in putting on your microphone.
Yeah, it's all right. If a young person wants to opt in and the parents want them to opt out, it can create conflict. although they can have sit-down conversations in the school and discuss it, it can create conflict behind the scenes. Young people, I think, understand how important education is in learning about different things. And some parents just like to stick to their religion and stick to what they know. So, yeah, it can create conflict in a way that if a child wants to go and learn about that religion, it can create conflict because the parent might not see what goes on inside the class and they might think they're saying something totally wrong about it or giving information that they don't believe in. So in that kind of sense, it can create conflict within the family.
That's really useful. Thank you. Any others of the panel want to come in on that? Juliet? Yeah. Oh, sorry.
Sorry, I was just going to say it has the potential to create conflict. You know, the ideal situation would be one where, you know, as my colleagues were talking about earlier, where, you know, parents at quite a young age would start to talk about these matters because they're important. They shape our lives. And that's what I think great parenting is all about, is when you can have these honest conversations with your young people and get them to reflect their wishes and their hopes, dreams and aspirations. But, you know, the law's fairly clear that parents don't just have an opportunity to get involved. We have a responsibility under the law and under, you know, UNCRC, where it says very clearly that we're responsible for the child's upbringing. That is going to include religious matters as well. And this is what worries me, is that we end up with a potential conflict, and one that could be expensive as well. I mean, I know that others will look at the final memorandum of this bill, but, you know, it would only take one or two legal challenges on this, and we could end up in the courts for an awful long time, and that concerns me, because that's not good for young people.
So, can I ask, in that case, are you saying that the decision should be the parents alone and not the child's ability to kind of overrule the parents' decision?
Well, as it stands, what the legislation has drafted is that the young person's rights would trump the parents' right. And I don't think that's right either. I think it should be, if you're going to do this, have a co-production. But I'd come back to my Hippocratic argument, which is first, do no harm. And all I can see this is doing is potentially creating conflict in a space where we don't particularly need it. I think the bill needs a fundamental rethink about how we balance the rights of young people and rights of parents to make sure that they're in harmony and not in conflict.
Okay, Juliet, you were wanting to come.
I think it does have the potential to create conflict, but so does the status quo. And the status quo is also open to legal challenge. And so I think doing nothing isn't an option. I think this is something that does need to be looked at. I think we need to kind of look more broadly and more holistically. We're obviously narrowly focusing this discussion on religious observance and religious and moral education as it's drafted in the bill at the moment. But actually teachers have to deal with sensitive topics with parents and their students all the time. They're always kind of balancing diverse needs, moral questions. This is a fundamental part of teaching. And so I think particularly now that we have the UNCRC Act, now that schools do have to further the UNCRC, we have more rights respecting schools. It's about culture rather than law, how we address these potential conflicts. And so I think it's so important that the law needs to be compatible with the UNCRC, and the school needs to have a culture, Scotland needs to have a culture where we can tackle and talk through these difficult questions and really avoid conflict insofar as possible.
There is an opportunity here, I think, to help educate all of us about how you manage and balance everyone's rights, and this is where the concept of evolving capacities is so key here, because the UNCRC does is very clear about the responsibilities, rights and duties of parents and carers in terms of raising their children and helping them to fulfil their children's own rights. But it recognises that children are increasingly going to be able to make decisions for themselves as they grow older with the support of parents. So there's a lot in the UNCRC, including in general comments, about what that looks like in adolescence and the balance then shifting in decision making from parents to children and young people. So there's probably a wider point here about actually just a public awareness about what does it mean to balance everyone's competing rights and how do we manage that well.
Okay, thank you.
Okay, thank you. We're going to move on to discussing part 2 of the bill, but before we do that, can I ask that your opinion on part of the bill amends the Education Scotland Act 1980. It's a UK Act, and it will not be possible to challenge a breach of these amendments under the UNCRC Act of 2024, as it only covers acts of the Scottish Parliament. So just to get your view specifically on that, what is your view on whether Part 1 of the bill achieves its objective to comply with the UNCRC, as well as providing coherence and clarity of the process for withdrawal from religious observance, religious moral education? Do you have any further thoughts on that approach?
Yes, certainly happy to come in on that. Firstly, in terms of compatibility of Part 1 as it stands, we don't believe it is compatible with the UNCRC for the many reasons we've set out before. In terms of the drafting style, we don't believe that it's been drafted in the way that really Scottish Government committed to when the UNCRC Act was passed. Ms Chapman might remember my evidence from children and young people to the Equalities and Human Rights Committee during the reconsideration stage of the UNCRC Act, where children and young people had described the UNCRC Act as a spider's web with holes in it, and the holes represented areas where perhaps acts of law couldn't be covered by the UNCRC Act because of the Supreme Court judgment. And they said it's the role of MSPs, of you, to be the spiders who mend these holes in the web. What this bill is doing is just leaving one of those holes absolutely wide open. So the Scottish Government have the chance with this bill to draft it in a way that doesn't reference back to the 1980 Act, that actually has this part of the bill as a standalone provision. And if it does that, it would be bringing it into the scope of the UNCRC Act. It would be mending one of the holes in the web. And so I remember the debate as the UNCRC Act was passed. I remember MSP saying, yes, we're going to mend these holes, we're going to be spiders, we're going to do all of this. And it feels like nearly 2 years on, that's been forgotten about. And so I would urge the committee in your role as human rights guarantors to really push on this, because we can't keep on having pieces of legislation that are being drafted in a way that is actually making the spider's web a bit more holy rather than bringing it all back together. So it's really something, again, it matters for this religious observance bill, but it also mattered for the Children's Care and Services Bill that's being examined at the moment. It mattered for the homelessness bill, the housing bill that went through Parliament the other day. Continuously, Scottish Government are drafting bills in a way that are leaving them out of the UNCRC Act. And it really goes against the promises that we made for children and young people. And this bill is a chance to do something about that.
Thank you. Anyone else like to come in on that point?
Wholeheartedly agree with that.
Thank you.
I'm actually going to agree, and also from a parental point of view. Right? Parents are the champions of their children. What we do most of the time is try and make sure that our children's rights are respected. And that can't happen if we don't have full access to justice. And the problem is with Section 2, that's where we are at the moment. And I think you will have lots of parents as well as young people that would be disappointed that they couldn't challenge necessarily in the courts if they thought that their human rights weren't being upheld.
Okay, thank you. No more indications. We'll now move on to questions from Tess White, please.
Thank you, Convener. So my question is around Part 2 of the bill. If I can come back to Juliet before I ask the question, I don't know if our role is to mend holes in webs and this hodgepodge of lawmaking is a huge problem. So in my head, and it was one question we explored last week, which is, why not recognise this is a hodgepodge? We wouldn't start off with here. We should wait for the Human Rights Bill and incorporate it all in that. So you're nodding your head there. Could you just address that point before I talk about your views on part 2 of the bill?
I think the issues with the Supreme Court judgment can't be addressed alone through the Human Rights Bill. So the issues that we're encountering with part 1 of this bill is the fact that it amends an act of the UK Parliament that, whilst it's completely within the scope of the Scottish Parliament, we're not allowed to apply human rights to. And so it's about drafting style. So rather than drafting a bill in a way that amends a pre-99 Act, then actually it should be drafted in a way that brings it as a standalone provision in an Act of the Scottish Parliament. So we would say, firstly, it's the job of Scottish Government to be drafting bills in a way that brings things into scope. But where they haven't, we would call on MSPs to hold government to account through the parliamentary process and say, actually, you need to go back, you need to look at this drafting style. It's unacceptable for us to have a bill that falls out of scope of the UNCRC Act that we voted in with cross-party support. So that's really kind of what I meant by that. I think with the Human Rights Bill for Scotland, it will encounter the same issues if we don't change the way that bills are drafted in the Scottish Parliament. So we have to address that at the source rather than through the Human Rights Bill itself.
Thank you. And then something that Gavin said before about justice and access to justice. Yeah. And if you're creating harm, more harm, you know, one of the areas that this committee is exploring is the legal aid. And the huge issues with legal aid, and we've got issues with legal aid for mainly women suffering from domestic abuse. Mm-hmm. And if we enter into this realm as well and introduce this bill, where this balance of rights between the parent and the child, and you've got to be a certain age and capacity to access legal aid. There's no access to legal aid for these children. So you know, Gavin, you point about causing more harm than good if there's no access to justice.
Access to legal aid is part of the issue. I mean, families that are struggling to get legally aided to try and get better ASL support for their kids as well. So it's a very, very difficult situation. You know, as I said at the start, you know, I'm not a lawyer. I don't really want to get into the weeds of Section 2, but it needs to be fair. It needs to be sorted out, because otherwise it will end up in the courts. And we don't want to make laws in this place, I would propose, where actually it's how it works on the ground is decided by judges. It should be decided by parliamentarians.
Thank you. Because one of the decisions we've got to make as a committee, when you go through stage 1 and then we'll have a report and then one of the decisions we'll have to make is, because we haven't heard to date, last week and today, anybody in favour of this bill, and we're using words like weeds and holes, and which is alarming. So my question is around part 2 of the bill and the reasoning given by the Scottish Government for this further exemption to the compatibility duty. What's your views on that? So if I can start off with Gina and then Juliet, Gavin, and then maybe go to Louise last. Thank you.
I'm going to apologise in advance because this is probably going to be very technical, trying to explain part 2 and what we think about it. In principle, we don't strongly object to the amendments that Scottish Government are proposing, but to enable our office to support the change, we've already indicated to Government that we believe there must be a duty on public bodies to report to the Scottish Government and to our office any occasion where they become aware of a requirement in law that is compelling them to act in a way that is not compliant with the UNCRC requirements. So if I go back a step to why Scottish Government says these amendments are needed, they have identified an issue whereby if legal proceedings have identified an incompatibility But for the support and protection of children, a service needs to continue to be delivered with the incompatibility in legislation until it can be remedied, or where out with legal proceedings, a public body has received advice that it cannot comply with a duty or deliver a function in a way that is compliant with the UNCRC requirements, but again, a service needs to continue to be delivered because there is a separate legal obligation for them to do so. That is why they think this compatibility exemption duty is needed, and we can see a rationale for that description. While we welcome the fact that the proposed amendment only applies where a public authority is required to act incompatibly, it must be recognised that these proposed amendments could have the unintended effect of undermining some of the aims of the UNCRC Act. The amendments might not just have the effect of protecting public authorities when they're delivering services that are incompatible with the UNCRC. It may also relieve some of the pressure on Scottish Government to amend incompatible legislation due to a lack of litigation urgency driving decisions, and make access to remedies for individual children more challenging by them being unable to directly challenge incompatible acts of the public authority in court. As a result of that, we believe that additional amendments should be considered to ensure that UNCRC incorporation is underpinned by strong systems of monitoring and accountability, and where incompatibilities are identified, they can be addressed swiftly and children experience remedy and redress in practice. There are 3 additional amendments we think are needed. The first is around, this is to the UNCRC Act, I should be clear, to the UNCRC Act. We believe that the incompatibility declarators in there could be broadened. So at the moment, incompatibility declarators under the UNCRC Act can only be issued by higher courts. The incompatibility declarators can also only be made in relation to post-commencement of the UNCRC Act provisions. We don't see any reason why incompatibility declarators could not be issued by a wider range of courts and tribunals in relation to relevant acts of the Scottish Parliament and subordinate legislation made at any time. This would enable those working directly with children more ability to address the issues before them. So courts and tribunals, for instance, the ASN Tribunal, Sheriff Courts dealing with family law proceedings and Sheriff Appeal Courts all have an important role in identifying and addressing children's rights issues. The Scottish Government has already said that one of its preferred methods to ensure that the existing statute book is compatible with the UNCRC is to respond to decisions of the courts. Our suggested amendment around incompatibility declarators supports Scottish Government's policy goal there by providing more courts and tribunals with the power to identify incompatible legislation both pre and post commencement. The second area we think amendments are needed are around the ministerial action that is required following an incompatibility declarator. So at the moment, duties on ministers when legislation has been found to be incompatible with the UNCRC could be strengthened. This would help address some of the access to justice gap that is going to be created for children who can no longer challenge incompatible acts of the public authority in court. Currently, the Act requires ministers to report to Parliament within 6 months what steps, if any, they intend to take in response to the declarator. We would like to see not only the timescale reduced to 3 months, and for this reporting duty to go further as well, requiring ministers to assess the impact of the breach on children and to provide that assessment back to the court or tribunal that issued the declarator, to the child affected, if relevant, and to our office as well. We've actually drafted some potential amendments here, which we're very, very happy to share with the committee as well. And the third and final one is around a statutory reporting duty. So there is a risk that incompatibilities will remain hidden and are not dealt with at a systemic level if public authorities don't have to notify Scottish Government when they become aware that legislation is obliging them to act in a way that is not compatible with the UNCRC requirements. We urge Government to revisit this point to ensure an enforceable and timely mechanism for reporting and addressing incompatibilities is put in place, and we feel these would address potentially some of the gaps that these amendments to the UNCRC Act might open up. Apologies, that was very technical.
I have no idea, absolutely no idea what any of that means. And I suppose that's part of the issue.
Yes, part of the problem.
Where you want more reporting, and it takes a lawyer to unravel what you've just said. Yeah. And yet there's access to justice, and if there's a conflict between a parent and a child, they've got to go through the legal system and find a legal aid solicitor, which is almost impossible. So you have just confirmed my concerns when you want more reporting, and COSLA are even saying there's no inventory of what exists in place now. So this would be bad lawmaking. I think I've reached capacity on that one. Juliet, would you like to answer the question about stage 2? But please, in a very simple way that we can understand, please. Thank you.
Certainly. So we consulted with our legal members on this probably about 12 months ago now, because we've known that this amendment might be coming, and they were broadly supportive of it. But very much with the caveat that they did not want to see it impact adversely on children's access to justice. We also consulted with children and young people about it, because we think it's really important that we get their views on what do they think about it and how can it be explained. And the way, when we were working with them, the way that we explained it, it's not completely legally correct, but it was imagining the religious observance bill was within scope of the UNCRC Act. So if you imagine the religious observance bill is in scope of the UNCRC Act, and a child is, sorry, this is pre-religious observance bill. So you've got a child at a school who is currently receiving religious observance from that school, and they want to opt out, but their views aren't taken into account. That child, as it stands at the moment, pre this bill, would have to, or would be able to challenge the school and say, we don't believe this is compatible with the UNCRC. And if that child won, that school would have to remove that child from religious observance. But the law would stay as it is. The law would still compel schools to deliver religious observance in a way that a court had already said has breached children's rights. And so really what this is doing in part 2 is meaning that actually the child can't challenge the school. So it is, in a way, reducing the child's access to justice, but instead the child, the parents, their legal representative, the Commissioner's Office, SHRC, would actually be able to challenge the government to say there is a law here that is incompatible with the UNCRC. So it means that that individual's child's access to justice, it has been reduced. And so the bits that Gina has talked about, I'll need to go back to my membership and consult with them to see what their views are on that. But that could be a way of addressing some of the concerns that our members had about reduced access to justice for that child. But actually, overall, it ensures realisation of the UNCRC. It ensures a clear legal environment, so public authorities know that they need to follow primary legislation, and if that primary legislation is deemed incompatible by the courts, they need to stop doing that. So it is something that our members broadly supported, but with the need for safeguards. And children and young people, when we were talking to them about it, and the children and young people we spoke to had been very involved in the reconsideration process of the UNCRC Act, so they understood the Act and how it might work. They were also broadly supportive of it, but again saying that there really needs to be clear instructions, clear guidance for children and young people about what this means, clear explainers. And we know that the adults always read the children's explainers as well, so it helps me to get my head around what the proposals actually mean. And so they said that needs to be put in place, but they would rather see the root cause of the rights violations being addressed by Scottish Government than actually seeing it being done on a patchwork basis, which is actually the situation that we would be in at the moment as things stand.
I hear you, but the point that we looked at earlier was the schools are the ones who hold the coats. And from even listening to you, Gina, and you, Juliet, if I was a teacher or a head teacher, I'd go to the council lawyer, legal department, and say, we've got this situation here, the parent can't agree, the child, we don't know what to do, can we have legal advice? So, and no wonder COSLA are concerned with all this. And if I was a head teacher in a school, I'd be massively concerned with this. Gavin, from a parent, teacher, child point of view, what's your...
That's our concern. I think what Gina's really... I think brilliantly set out, though, is a kind of, well, there's maybe a way we can fix the 2024 Act. We can fix it in the mix, right? I don't think this is the place to fix a substantial, huge piece of legislation. That would worry me, right? And that's not from a legal perspective. That's just somebody that's worked around politics for 30 years. You know, this is one of the issues with these kind of portmanteau bills, where we try and go, well, it's not kind of working the way we want it, so let's just like amend it a little bit and maybe we can make something work. Well, there's a lot of digging around those weeds. It may be a bit of genius. I certainly hope it is. But from my perspective, I've not heard enough from all of the evidence that I've heard that we've actually got a full grip on this. And again, I don't want to cause any harm. I'd rather make things better.
Thank you. And what's just happened there with the three witnesses working together from different angles is a beautiful cameo. And now I'll go to the student. And Louise, what's your view of all that and what you've just heard of that? How would you see it unpicking this, and any additional thoughts that you've got?
I'm not going to go into quite as much technical detail as everyone else, but the Scottish Youth Parliament have been long-standing campaigners for the rights of UNCRC and the rights of a child, and especially incorporating it in Scots law. And every young person wants to have their rights protected as far as possible, so any opportunity that takes to keep these rights and make sure they're protected is really, really important and should be taken at any opportunity. I know that's not quite as much detail, but that's about as much detail as I can go into on that.
Louise, that's brilliantly summarised, and thank you for that. Back to you, convener.
Okay, thank you. And I appreciate the dry technical points that you have to make today, but it is important that we do get that on record, and absolutely we would appreciate if you wanted to send those amendments to have those, so we could get a bit of an understanding where your views are coming in there. But we do have a fantastic Scottish Parliament team that supports us with any legalese that can help us MSPs make headway on these things. So thank you for that. We now have questions from Marie McNair, who's joining us remotely.
Thank you, convener, and good morning, panel. Thanks for your time this morning. I'm interested to hear your thoughts on the potential impact of Part 2 on children, public authorities and on future legislation such as the Scottish Human Rights Bill. You've probably kind of touched on bits of it, but just wanted to know if you wanted to expand a little bit on it. And I'll go to Juliet first, if that's okay.
I'm not sure I've got that much more to add to what I've said already, that our membership is broadly in support of Part 2. We do believe that it will provide clarity, both for public bodies around whether or not they should be following primary legislation or whether they should be following rulings of the courts against specific cases. We do agree with some of the evidence that you heard last week about the impact that it can have on children's access to justice. So I think any work that the committee could do to take into account the suggestions from the Commissioner's Office to try to ensure that this doesn't negatively impact on children's access to justice, I'm sure that we would be really keen to explore. I have to say the potential amendments that the Commissioner's Office have recommended today do sound interesting, and I would be really keen to engage with our Together membership again and come back to the committee with our view once we've had the chance to digest those, because if they address some of the concerns that were raised, that would definitely be a good thing.
Thank you, Julie. Anyone else? Gavin or Gina?
So in terms of the broader question, what does any of this have on the future human rights bill? I think it's important to recognise that UNCRC Act and incorporation is still relatively new and is still bedding in. We're working out all the kinks in what it actually takes to implement incorporation across Scotland. So all of the learning that we're gaining from the implementation of that Act is all extremely relevant for the Human Rights Bill. So these amendments that we're looking at potentially around Part 2 are all really valuable for any future work on a Human Rights Bill, because we need to learn from the incorporation model that we currently have and any potential weaknesses that exist in it, so that we can make sure that we strengthen it in future. And I would raise again, I know we've touched on it already several times, but the issue of the way in which this bill has been drafted, Part 1 has been drafted, to our office indicates a slightly concerning trend from Scottish Government that they're not prioritising drafting legislation to be in scope for UNCRC incorporation, and that does potentially signal a worrying lack of commitment. So there's probably something there as well in terms of what relevance is that for the future Human Rights Bill.
Thank you. That's helpful when we compile the report. Gavin, do you want to say anything, or is it covered?
I'll be really brief. I would agree with much of what my colleagues have said. What I would say, though, is that just to pick up is the idea that this is early days, and it is. Part of my job is I work with teachers, I work with parents, I work with local authorities as well. And what they tell me is they haven't even got their heads around child-centred complaints yet. Okay, that's still a guddle. I think that's the technical legal term for it, is it, Gina? A guddle. So my concern is really with this, is that we are biting off quite some large chunks, and we can't afford to get it wrong.
Thank you, that's really helpful. Louise, don't want to put you on the spot. Have you got anything else to add? It's okay if you don't, not a problem.
No, I don't have anything more to add.
Not a problem. So last week, obviously, it was mentioned that Part 2 shouldn't be in the bill because it's so distinct and different from Part 1. Obviously, again, you have kind of covered that earlier on, but anything else you might want to tell the committee? And I'll pop it out to Gavin. Again, Gavin, if you've got nothing, it's okay. But if you
just to say, I'm always wary of portmanteau bills where you end up with conflation. So that's my concern.
Thank you. Anyone else?
I can understand why the two things have been brought into the same bill, because the intent of the bill, we don't believe it does it, but the intent of the bill is to address an incompatibility of the UNCRC. And Part 2 is about what you do when primary legislation is incompatible with the UNCRC. So there's definitely a logic as to why they've been put together in the same bill.
Thank you. Gina, have you got anything?
Okay. Have I lost Marie? No.
Gina, have you got anything?
Oh no, sorry, I said no, nothing else, nothing to add.
Oh,
sorry.
right,
Thank
okay.
you.
And last but not least, Louise, any kind of last minute thoughts? No? No, okay. Back to yourself, convener then. Thank you.
Okay, thank you. Apologies, Marie, I thought you'd frozen there for a second. That brings our first panel evidence session to a close. I want to thank you all again for attending this morning, and we will now suspend briefly for a changeover of witnesses. I would now like to welcome our second panel of witnesses today. Dr Douglas Hutchison, Executive Director of Education, Glasgow City Council, representing the Association of Directors of Education in Scotland. Susan Quinn, Convener, Education Committee, Educational Institute of Scotland. Good morning and welcome to you. We're now going to move straight into questions, and I'm going to kick us off this morning. We've had some critical feedback and views from our three panels last week and also our first panel this morning with various critical viewpoints on this bill. Can I ask you, what are your views of the general principles of the bill? If I can come to you first, Susan.
So the EIS overall would be supportive of the intent of the legislation, particularly around to give greater children's voice. We firmly believe that that needs to be considered, but we have significant concerns about the apparent underestimation of resources required for implementation, the impact on workload and relationships potentially that's there, and we don't feel that the bill does fully realise what our policy intentions would be around the rights of pupils within it, and the current lack of clarity of a number of practical issues in terms of the implementation. So yes, the idea is all right, but actually what's there and the potential for it is problematic for our members.
Okay, thank you. Douglas, please.
Yeah, similar in some ways to the EIS, the policy intention is right to improve children's rights, but I'm not clear that this bill, as it sets out, achieves that policy intention of improving or progressing children's rights. I would have a concern that religious and moral education is seen in the same light as religious observance. I think the two are very distinct. And I would have concerns about the practical implications of a requirement to ensure that parents have taken account of children's rights, and how do you evidence that parents have taken account of children's rights when they exercise a right to withdraw. But going back to the religious and moral education versus religious observance, religious and moral education, I think, should be seen as a curricular subject like any other curricular subject. I can't understand the idea that you would have a conscience clause. That made sense in 1872 when religious education was religious instruction, because schools transferred largely from the Church of Scotland into the state system. The 1980 Act largely replicates what's set out in the 1872 legislation. The world has changed since 1872, and religious and moral education has changed since 1872. So the idea that there isn't a place in a liberal democracy for religious education in the curriculum and that there's a right to withdraw just doesn't make sense in 2025. And so it should just be considered like any other subject. Children don't have the right to withdraw from physics if they think the world is flat. So why would they have a right to withdraw from religious education? Religious observance is different. I would remove the requirement, the legal requirement to have religious observance at all. Religious observance is a free response in faith, and I don't see any place for it in a non-denominational school, so I don't see why there's any legal requirement to have religious observance. Curriculum for Excellence sets out four key areas where the curriculum is delivered. That's through curricular areas and subjects, interdisciplinary learning, personal achievement and ethos and life of the school. If a school has an assembly that celebrates the ethos and life of the school, that's curricular. And why would you have a right to withdraw? Because it's part of the school. And so that's not religious observance, that's celebrating the ethos and life of the school. That's in non-denominational schools. It's different in denominational schools. I can understand why there would be a right to withdraw in non-denominational schools, but in local authority, non-denominational schools, there shouldn't be a legal requirement to have religious observance.
Okay, thank you. We'll now move on to questions from Maggie Chapman, please.
Thanks very much, Karen. Good morning to you both. Thank you for joining us this morning. And Douglas, thank you for very clearly articulating what I think we've heard from every panel and probably every member on every panel since we started this scrutiny. That distinction between religious observance and religious and moral education, and I think that's come out loud and clear. It is because we have to deal with the bill in front of us. That we are still talking about both, but I think we all as a committee get the need to separate that. So I'll take that as understood. I'm interested from both of you in your views on how things are currently working, how levels of awareness around the right to withdraw are, how schools and teachers deal with some of those potentially awkward conversations around this. Susan, can I come to you first on this?
Sure. As well as being education convener for the EIS, I'm a primary head teacher, and I guess that in schools we deal with things on a day-to-day basis and look to deal with them as practically as we possibly can. I think we've seen across the country that the numbers actually seeking to withdraw are small at this time. Why that is, who knows, whether there's an awareness or whether people are accepting of what's there and understand that the things that happen within their schools are balanced and considered, and it's actually a good thing for the young people to have wide experiences. I can't speak to parental choice or otherwise, but I think we do find that where we see larger numbers of young people, families looking to withdraw from religious observance and RE, then it becomes problematic because of the resource that's available. Because, you know, as a parent, you would be perfectly entitled to expect that if your young person's not attending Mass, for instance, from a RC school, that they would be being taught for that period of time by a GTCS registered teacher, and that can't happen. You know, in real, genuine, practical terms, and in lots of areas we will have schools where the potential is for a large number of young people to seek to be, or young people's families, because it's not the young people that are seeking to withdraw, and that's part of the issue. It's and that if there are large numbers, then you have real difficulty, real capacity around that happening. You know, buildings aren't big enough to have an extra room for that to be the case. We don't have enough staff to do that, or you're taking the staff away from something else that means that young people are losing out on things. So in terms of the practicalities of it, I think schools at the moment will seek to have conversations with parents around what might legitimately happen if they do exercise their right to withdraw, and be honest about the challenges that they will face in providing quality education during that period of time. They'll then have a conversation with their local authority about how they can best support if that's something that's to be done. But it is problematic.
Okay. Thanks for that. And I suppose two connected follow-up questions, picking up on what you've said. One is around well, you framed it in terms of resourcing, and I think there is genuine concern about what this means for how the school looks and deals with these things. Would it be helpful if we actually quantified this, if we had better data, if we had a better understanding of how many parents, how many young people, how many families this could be affecting, because and use that as a sort of an evidence to request further resources, that kind of thing? Because at the moment we don't collect data on this. There's no regularised or standardised mechanism, even within schools, as we understand it, never mind across local authorities or across the country. Is there a role for better data collection in this?
I think you'll only get the data what's happening at this point in time, and that's when it's it's not hugely publicised. It's not the need for us to put any changes into a handbook and to publicise it, and things may well change how many are looking to withdraw, and that you can't anticipate that just from the data of what's currently happening. What you can see are changes in demographics of schools and how that might look around it. But yeah, I mean, obviously data's helpful in the terms of what's there, but I don't know that you'll get very much out of knowing how many are now, because this is to project a change that then could significantly increase it, and that's we can't can't jump forward to anticipate that.
Yeah, no, that's helpful, and I suppose my second follow up is really from the young people and families' points of view. In your experience, the way the system currently works, in your experience and speaking to other teachers, has there been either a reluctance for young people to approach a member of staff because they don't want to be stigmatised, they don't want to be othered, they don't want to be marked out as different? Or do you see othering and stigmatising as a potential issue in the way that the system currently works?
No, I don't think so in terms of the way the system currently works. We're not hearing a lot of that. We have, there'll be our schools are always cognisant of individuals and of the situations that are there, so they will always do their best anyway to accommodate. Say the potential is that if this increases, through changes to legislation or otherwise, that it becomes more problematic for schools to be able to do that. Yeah. But schools at this point, I don't think there's any particular evidence that we've seen anyway in the EIS that suggests that there's been any of that under the current situation. What is that is that you've not got young people able to, if it's a request for withdrawal, it's a parent that's making the request to withdraw. Now that's not changing with this. The child's got to be considered more clearly within it, but a young person's not coming forward to say, I want to exercise my right to withdraw, because they don't have that right under the current situation or the potential from this. I think the challenge, as you've said and as others have said, is that I suppose potentially it's what happens if you see what we put in place. If we have an increase in young people being withdrawn from religious observance, let's accept that we deal with the RME part of it, because EIS would agree with Douglas and others. That's a curricular area, and it's a slippery slope if we're looking to give parents the right to withdraw from curricular areas, because we know some of the challenges that are faced around that. I can see that, at least at the very beginning, you might find that there might be a bit of a impetus around young people going, my pal's not having to do that, so I'm going to ask my mammy to withdraw me, and then there's a tipping point, and it becomes so if they're not seeing what's, I'm not suggesting that they should be sitting doing a whole lot of lines whilst they're at religious observance. I don't think they're compatible. But it's that they're young, and that's if you can listen, if you can get time away from doing something in school, then that's what you're choosing to do. So I think there's a challenge for us around some of that.
Okay, thanks. That's helpful, Susan. Douglas, same question to you. Your view of how the current system is working from your point of view, and where you see some of the challenges or pitfalls.
At present, In terms of the right to withdraw from religious and moral education, I'm not aware of that being a major issue.
Okay.
I mean, I may be wrong, but anyway, I'm not aware of it. In terms of the right to withdraw from religious observance, it's again, it's not a major issue impacting across the system, but it's probably becoming more of an issue, particularly in a denominational school where the majority aren't actually Catholics, either, you know, like by association or by commitment. In a primary school, for example, if they're going to a First Friday Mass on a Friday morning and a school of 270 of them don't want to go, that's a logistical problem for the school. I suspect it's more of an issue in denominational schools than it is in non-denominational schools, because non-denominational schools have broadly moved in the direction of a celebration of the ethos and life of the school, which is entirely consistent with curriculum for excellence, I would say. As Susan was indicating, it has the potential to become more of an issue, and it's the practical issues, and that's probably what ADES highlighted, the practical issues of, I mean, strictly speaking, UNCRC, you would expect that the child would have the right themselves to say, no, I don't want any part of this, rather than this fudge in the document of, you know, parents have the right, but ask the child, or whatever it says, you know, like. Strictly speaking, if a child has the right, exactly as Susan says, you know, like, we're all going into the Assembly Hall, a school of 150, and half of them say, no, I'm exercising my right. So what's the head teacher going to do with them then? And in terms of the practical reality of it, that could be hugely problematic, you know, if it builds up a sense of momentum. The solution for me is remove the requirement to have any kind of religious observance in a non-denominational context. Catholic schools are different. Calderwood Lodge, the Jewish schools, different. It's reasonable of parents to expect some kind of faith element if they choose to send their children to a denominational school. It's reasonable to expect that, and in that context, there will likely be some who would say, no, I'm here, but I don't want that part of this school, and that's reasonable. In a non-denominational context, I can't see why you would expect any kind of expression of faith.
Thanks, that's helpful. Just on that last point, we heard in our first panel this morning the suggestion that actually there might be, you know, there's never been a thematic review of religious observance in schools, or certainly not one recently. There may well have been prior to the 1980 Act. But is that something that ADES would support or consider, given what you say about the removal of the requirement for RO in non-denominational schools?
Would ADES support a thematic review? Wouldn't be my top priority, I would have to say. I think we've got more pressing issues than the quality of religious observance across the country. When I was HMI, when we did a thematic review of religious and moral education, and there was probably a discussion at that time of having a look at religious observance, but stepped back and only focused on religious and moral education. It could be done. I'm just not sure it's top priority, that's all.
No, that's helpful. And the question about data, from your experience in Glasgow and with ADES as well, I mean, well, in Glasgow, is there a systematic way of recording withdrawals from RME at the moment? Are you aware of schools actually collating data in a standardised way?
No. Probably because that isn't a major issue. You know, I'm aware of the one or two schools where there are increasing numbers exercising their right not to in denominational schools. But it is very small numbers and it's not collected systematically. I mean, the expectation is clearly that the current position is there should be the statement of a parent's right to withdraw in the school handbook. The right to withdraw from religious education and religious observance, so that should be in every school handbook. but beyond that, we don't collect any data, and I'm not aware of it being a particular problem, other than in a very small number of schools.
Okay, and in that small number of schools or elsewhere, are you aware of any questions or concerns that parents, young people, or teachers have observed around stigmatising or othering of the young people if their parents do withdraw them?
No, not at all. It's likely. My experience is it's say a denominational primary school, a Catholic primary school, where there's a significant Muslim population who would choose not to go to the church, which is situated nearby, which is perfectly reasonable. Yeah. So it's not. They have a strong identity as, you know, a Muslim community, and that's simply not part of. They're happy to be part of a denominational school, but not take part in that bit. So there's no sense of them being othered or stigmatised or anything like that.
But it might be an issue if there's maybe one individual rather than that clear community with a strong identity. Just from what we've heard, certainly last week, you know, maybe people being unwilling to even raise the issue for fear of stigmatisation or othering. But that's not your experience. That's
no, it's not my experience. I'd have to say I'm not aware of that.
Okay. No. That's
and I mean, I'd have to say, in terms of complaints, it's not something I've had. I mean, I've been director or head of education for 12 years now, both in Glasgow and South Ayrshire, and it has never crossed my desk as a complaint.
Okay, thanks. That's helpful. I'll leave it there.
Okay, thank you. We now have questions from Paul McLennan, please.
Thank you, Convener. It's maybe more on the Bill's process, and it's the same question asked to the last committee, and it's kind of about the requirement for schools to inform a child if the parent asks for them to be withdrawn from RO and RME. When a request has been made, the child is given an opportunity to express their views, and that the school must seek a discussion with the child. And that a school must respect the child's wishes if their views differ from the parent. Susan, I'll probably come to yourself first of all, obviously, just in terms of your experience as a teacher. And so I don't know what your thoughts are on that and the process that's been at hand.
I mean, I think there are potential real challenges around it in terms of workload, resource, you know, ability to do this. And the potential around breakdown in relationships between a school and a parent. If a parent has brought forward something that they want, and then, you know, somebody in the previous session mentioned the children's complaints and friendly complaints, and we're looking at that just now, and it makes me go, oh my goodness, I can see a fallout here happening, and that's the challenge of it. And I think that's then what that looks like. And some of the questions and conversations from our members are around at what age can a young person properly consent.
That was going to be the follow-up, because you've probably heard from the last session and the sessions before that. I think the point I made was you could have a mature 8-year-old and a mature 12-year-old, and you know, so where's the line?
So where's the line, and then how do you consider, when you know your families and know what's happening, what the impact for a young person saying no to their parent might have when they go up the road, and challenges. So there are a whole lot of concerns for us in terms of how that might play out for our teachers, for our staff who are having to relay the message to a parent that no, their wish has not been taken forward because their child has said they want to continue with it. So that's a potential difficulty. That is about time, you know, genuinely. As a primary head teacher of a good number of years' experience, I'm not actually aware of any head teacher that's sitting twiddling their thumbs, that's needing something extra to add in terms of conversations with young people around that. We're speaking to them all the time, but I think if you're putting something like this in place, because it's going to have a potential conversation back with the parent, then you're going to have to make sure that you're doing it properly. And I can see that, you know, that they could bring challenges for us. And I think that, and then I say we'd have concerns about a young person saying no to their parent, and what I know what my mum would have said to me if I'd said no to what she had to say. Now that's a long time ago, but I think we'd have our concerns,
and you've got different
different family dynamics and different challenges. So I think our members would have concerns, but it is that whole thing of at what age as well. It's not clear what we're saying in this. You know, are we saying that, you know, a 4-year-old has the right? I can see a child, even an 8-year-old or whatever, if it's the teacher asking them or their head teacher saying to them thinking, I've got to please this person, so I'm going to say they want me to keep doing this, so I'm going to say I'll agree with the teacher, but then, and I think it'll give them some real challenges.
Yeah. Douglas, have you anything else to add on?
I would absolutely agree with Susan. I just see it as difficult to imagine any, as I said in the consultation response, any straightforward or consistent mechanism to make this work that wouldn't be burdensome on the school and onerous for the child and parent. And I mean, one of the regular issues that comes up in schools is two parents who are separated and both have parental rights and both have entirely different worldviews. And, you know, so it becomes even more complex in those circumstances. So it's difficult to imagine any way that it could be operated straightforwardly or simply that isn't burdensome for the school and challenging for the parent.
And I suppose just maybe an extension of that as well. In the last committee we asked about UNCRC, and it was specifically mentioned what was said about Article 12, the right to be heard, and Article 14, the freedom of thought. I don't know what your thoughts are in terms of that. We've heard from various panels now that, you know, there's issues around about the compatibility with the UNCRC. I don't know what your thoughts are in terms of that.
I think the challenge for us isn't whether it's, you know, the compatibility or otherwise. I think the challenges for us are around the practicalities of it. I think some of it becomes quite legalistic, and that makes it more difficult for our schools to implement and to consider. Douglas is right, we already have situations where two parents can't agree on a course of action, and the potential is for this to be more problematic. The fact is that for a young person to be heard, this only hears them if their parent makes a request on their behalf in the first instance. A young person who themselves has developed conscience and wants to withdraw isn't heard, so it doesn't do that part to it. So I'm not sure what more it does, you know, on what we currently have.
Yeah, Douglas, anything to add on that?
Yeah, when I was preparing a response on behalf of Glasgow City Council rather than ADES to the consultation, I asked some of the faculty heads of RME in the city, and in terms of their response, they specifically referenced Article 14, freedom of thought, belief and religion, and it was their view that withdrawing or devaluing religious and moral education by continuing to allow the right to withdraw diminished Article 14, because how can children and young people understand belief in religion if they're not exposed to it as part of their curriculum experience? So they saw this as a potential threat to their Article 14 rights, and I thought that was a reasonable point to make.
That's pretty clear. Okay, thank you, convener.
Thank you. We now have questions from Rhoda Grant, please.
Thank you. So we've heard that there is a distinct difference between RO and RME, and RME should not really be in the bill. And Douglas, you'd also said that you didn't think that RO should be a legal requirement for non-denominational schools. And I want to ask Susan if she agrees with that. But also, I wonder if I could push a wee bit further on what you mean by that, in that we've had evidence, for instance, that you know, nativity plays and those kind of things that go on around Christmas time in schools can be viewed by people who don't have a Christian faith or background as being very much like RO, and their children being asked to observe Christian traditions that are not part of their own beliefs.
So in terms of the opening part, the EIS don't have a position on whether RO should be withdraw, you know, should be present in school. That's not that's not, no, we haven't got policy particularly in that area. Our policy is around a right of a child to withdraw from it, and you know, and that is where we would seek to welcome children being more and having the right to do so. The legislation doesn't give the child the right to do so. I think there are so. In non-denominational schools, I think that Douglas's point around the kinds of activities that take place that celebrate the life of and the ethos of the school would cover things like the nativity play and things, because they would be covered under RME, because part of the RME syllabus curriculum would be around an understanding of Christianity and the particular celebrations of Christianity in the same way as it would have for other aspects of religious lives. And so I don't see I don't see that as being a problematic area. I think that there may well still be people who might wish to withdraw, but that's the whole point, is whether or not they should have the right to withdraw, but the IS doesn't have. That's not our position. But I think you can legitimately speak to having assemblies and celebrations which focus on different aspects of religious and moral education within it, and their curricular development. They're part of the life of the school.
Okay, Douglas.
I'm not 100% clear what your question is, because I would probably agree with those who say that they question, say, having a nativity in a non-denominational school. I think it's a reasonable question to ask. You know, if you're in any school in Glasgow, they are very diverse. I mean, 26% of our children and young people have English as an additional language, and they come from a huge variety of cultures, religious backgrounds and no religious backgrounds. So the idea that we would have something in a context where a predominant group in the school are Muslims that is very Christian-centric is questionable in a non-denominational context. And last Christmas I went to an event in a primary school in non-denominational primary school, and it was a genuinely multicultural event. You know, they had incorporated aspects of multiple faiths into this kind of, wasn't a nativity, it included expressions of a broad range of faiths, which I thought was, it was very inclusive. So there are ways to do it. Again, I go back to what I said already. The ethos and life of the school is one of the contexts in which curriculum for excellence is expected to be delivered. And it would be for that school to determine how they express their vision, values and purpose, how they express the ethos and life of the school as a community that reflects their community. But any event that reflects one part of the community and excludes others is problematic for me. And that's why I would question the legal requirement to have religious observance in a non-denominational context. Because by definition, religious observance should be a free response in faith. And if there's no faith community there, why are we requiring young people to take part in that? Why, as a country in 2025, do we require any form of religious expression or faith in a non-denominational context? Anyway, so... yeah.
No, that's useful. My other question has been, I think, pretty much answered, but just for clarification, about the the potential conflict between parents and children. I think we all understand that there's a preference that the child makes the decision, that the bill should allow the child to have that decision, but actually they only have that decision if their parent opts them out. That's the only time they can take a decision that might be contrary to their parents' belief. Is that creating conflict, or would there be more conflict if the child was able to take that decision for themselves and instigate that decision?
So I'm not sure whether there'll be more or less if the child had the right to put forward first. But I think the challenge for us around what's here is that there's no limit to how many times a parent can make the request. So, you know, in extreme circumstances, you could see that a parent might make the request, conversations happens with the young person says no, they don't want to opt out, they continue, parent comes back in a few months' time. How you know it's as adults we can be broken records in the same way as young. It doesn't preempt you from wanting to have your way and to do it. And the challenge within it really is that what if a young person also then changes their mind? So if they, in the first instance, said, yes, I want to, I'll go along with my parent, and then a year into it feels that they're missing out or would be interested in seeing, then they can come back and change their mind on their decision. So I'm not sure whether or not there'll be more or less challenge if the young person had the right to put forward their position in the first instance or not. But I think that what's here has potential for causing more problems generally.
Okay.
I'm not clear how a parent would evidence that they had taken account of their child's views, or how a school would assure itself that the child's views had been taken account of before the parent made the request. It just seems I'm just not clear how it would work in practice in the real world if, you know, Susan as head teacher was faced with a situation. I'm just not clear how Susan would convince herself that a child's, you know, views had been taken account of, and if there was any conflict. I'm just not clear how it would actually work in practice.
Okay, thank you.
Thank you. We now have questions from Tess White, please.
Thank you, Convener. Just to hear if you've got any views about the approach that the bill is taking, and part 2 of the bill. So we heard some really strong views last week, and we've had some strong views this morning. So if you just have any additional thoughts on that. Susan, I'm looking at your face there to see.
I mean, I don't think I've got anything particularly additionally to say in what I've already said. I think we have, the EIS have concerns around the implementation of such a bill in terms of resource, in terms of the ability to maintain relationships, in terms of the ability to support our young people effectively within it, and that's where that our challenges really sit, as the practical side of things. We don't believe it goes far enough in terms of the children's rights, but beyond that, we think there are real challenges in terms of the practicalities of the bill.
And you're saying earlier, you said that you've got enough on your plate right now. This is just one extra burden.
Yeah, I think that the potential is for it to be an extra burden where we already have a lot of things that need to be addressed. And Douglas has said in terms of whether or not we needed a thematic review, there are a whole lot of things I think that are potentially more important within the system for us. We have something in place that happens just now. It doesn't happen in very many places or in significant numbers, but I'm not sure whether there's evidence to suggest that there's been a cry for that. But yeah, it's the practicalities in terms of how we do this in a way that doesn't add significant workload and stressors to relationships within school communities.
And I suppose COSLA have also said that they've looked across and there's been no mapping, gap analysis, data collection. So how can you actually do this if you've not actually done the prep work?
Yeah.
Okay, thank you. Douglas?
Yes, largely similar. I'm not in about the detail. Some of the previous contributors have seen knew the detail incredibly well. Like Susan, my concern is the practical application of what is proposed. I mean, like Ms Chapman referenced othering children and young people. I see this as othering religious and moral education and diminishing its place. If we have a right to withdraw, for example, you know, if it's treated somehow as if it's still religious instruction from 1872, which it isn't. And I do speak as a former RE teacher when I earned an honest living. This seems to me to devalue. So it's the practical application of what is proposed that concerns me, and the potential for having large groups of young people, you know, exercising the right to withdraw from religious education, any form of celebration of the ethos and life of the school. It gives huge issues. The potential conflict between a parent and child, between two parents and a child, the practical application of it for schools and local authorities, and the potential for us to get involved in further litigation is problematic. We're already up to our ears in ASN tribunals and other issues. This just opens up a whole other seam of issues for us. So it's the practical realities that concern me.
Thank you. I mean, that's really powerful feedback to this committee, particularly bearing in mind the previous thing. It was Connect said this bill, if it goes through, could actually cause harm. You're saying it could cause conflict. They went even, well, the last witness said it could cause harm. What's your view of that?
I'm less clear about harm. I'm more concerned about practical reality. You know, if you're a head teacher of a primary school with 160 children, you struggle to manage your reduced class contact time. You do that generally by having, you know, in part an assembly on a Friday morning that will, you know, give out awards and all the rest of it. And if suddenly, you know, like the rest of the teachers are away getting some of the reduced class contact time, you and the deputy are taking the assembly, suddenly you've got 65 children who say, sorry, no, I'm not going to that. That's religious observance. It's just the practical implications of what could potentially happen that causes me concern, and the idea that we will be involved in potentially further litigation makes my heart sink.
Thank you. And Susan, I can see you want to come in.
I would agree with Douglas on that, and I think, again, it's not overstressing the RME part of it, but potentially it is, because you've heard it a lot. There is a real danger if we are looking at a right to withdraw from RME being bigger, then, you know, why wouldn't a parent come forward or a child come forward and say, we want to withdraw from PSC because we don't agree with what's been taught in PSC, or I'm not sure about the flat earth, but, you know, we don't agree with, you know, this isn't our priority for our young person. Why are they having to learn 2 extra languages when they are struggling with their literacy in English? So they shouldn't have to do those. And I think there's a real danger around it. You know, it's starting to escalate and to provide those kinds of challenges too. It does. RME is part of the curriculum that provides an opportunity to look at the wider world and to provide our children with a learning experience that can help us to become more tolerant to become more understanding. And if there's anything we're needing just now within the world is an understanding of each other across it. So I think there are challenges. I wouldn't speak to harm because that's something much more advanced. But there is potential for conflicts there because that's the nature of human beings.
So you're using the word danger. We've heard Douglas conflict, we've heard previous harm, we've heard holes in the web, we've heard weeds. So thank you for that. I'm going to pass back to our convener. Thank you.
Okay, thank you. We now have questions from Marie McNair, who's joining us remotely.
Thank you, convener, and good morning, panel. My question is kind of covered, but I'll ask it, and maybe you can add a wee bit if you've got anything else that you want to say. What are your thoughts on the potential impact of Part 2, for example, on children, public bodies, and on the future legislation such as the Human Rights Bill? Again, I think you've covered quite a bit of it, but if there's anything else you want to add, Douglas or Susan?
I really don't have anything else to add on the discussion around Part 2 at this point.
Okay. Douglas, do you have anything? Not putting you on the spot, but if you do, feel free. If not, I'll hand back to convener.
Not really in relation, not specifically in relation to Part 2. As I said, I'm not particularly going to get into the detail of the legislation, other than what I said probably in my submission on behalf of Glasgow City Council, that we are trying to solve an 1872 issue in a 2025 context, and I'm not sure this is the answer. There are complex issues that need to be resolved here, but I'm not convinced that the Act takes us, or the Bill takes us forward in addressing those issues. It simply complicates and slightly fudges the issues.
Thank you, Douglas, for that. Back to yourself, convener. No further questions.
Okay, thank you. That now concludes our questions this morning. Thank you once again for joining us. We will now go into our private session to discuss the remaining items of our agenda. Thank you.